Uh, So thank you, Chuck, for taking out time for us. Please, a little introduction of yourself. It's your show. After that, I'm out.
Okay. Thanks, Vikram. I really want to start by thanking you for putting together this symposium. You said yourself that I'm speaker number 35, and we still have quite a ways to go. Miles to go before I sleep. So you've done. I don't know if anybody has done something at this on this scale up until now in the international mediation community. And of course, I mean, partially it's enabled by technology that we're already, after a year and a half of this, been accustomed to think that we're actually meeting each other. That we're sitting in the same room, that I'm actually sharing the coffee with Giovanni or something like that. And so it becomes natural to meet in this sort of way. So it's kind of confluence of your initiative and your talent and the technology, and this is the way forward, I think. You billed me as a speaker from Germany. Actually, I wanted to focus a little bit more on the place where my mediation tradition comes from. That is to say, where I spent most of my time and where I underwent my first mediation as a party. I underwent a mediation as a party before becoming a mediator, where I trained. But I have to give Germany its due as well, and because I think Germany is a fairly special case in terms of the culture of mediation that we're looking at here. So, in fact, my talk is going to be divided into four parts. The first part, I'm going to introduce myself, but the other three parts then will be a very short overview of the situation of commercial mediation in Germany. The second will be a bit of background on mediation in the Jewish tradition. We'll go a little bit deeper into the sources there and kind of the role that legal issues, let's say, played in the life of the Jewish communities over the course of history. And the third is I'm going to pose some questions to the audience concerning culture of mediation, and to see how we've coped with that, how Israel is coped with it or tried to cope with it. And I'm going to be a little bit critical down the line here, and I'd like to hear from other people's experiences as well, how this can be promoted. So let me begin with, I believe I have to open my, hold on a second. Right.
At any point of time, Chuck, I can always change that Germany to Israel. Any point of time, whenever you want me to.
We'll start with Germany, and then we'll see how it goes in terms of Israel. Shift tab, will that do that? No, escape. Okay. I will now share here. And we will begin now. Okay, so you can see my title is actually connected more to Israel than it is to Germany and to the Jewish tradition. But as I said, we'll understand shortly why I have very little to say about Germany and the situation here. I'm going to click through now to my ego slide. This is my ego slide with all the stuff that I've done that I can present to everybody. But I'm going to give a few seconds to look at this, and then I'm going to go to another slide, which isn't so distracting. So that one is just the story of my path. To give a little bit about myself, I was born in the United States. I grew up in the United States and moved to Israel at the age of 18. Once I was there, I studied law. I passed the bar, and I practiced law in, I guess, what would be the most non-collaborative of possible legal structures, which is that I was a public prosecutor. for a number of years. And that was enough actually to convince me that I didn't want to practice law anymore ever again. In fact, the situation is such that I was actually fired from my job as a prosecutor. One day, my boss, who is kind of the district attorney, called me in, and he said, "Listen, you know, we've been getting some feedback that you're too empathetic to the other side, and you see, whenever you try to present in court, you keep presenting both sides of the question, and that's the judge's job and not your job, and so basically you're out." And so I went into I decided to go into a more collaborative profession, and that's diplomacy. I was in the Israeli Foreign Service for just about 25 years. One of the interesting things about diplomacy that a lot of people don't necessarily think of, when you think of it, you know, you think of people of my age about talks between the United States and the Soviet Union, you know, the START talks and the SALT talks, and very kind of adversarial sort of talks like this, or now between the European countries and Iran concerning nuclear disarmament and so forth. And it's very kind of adversarial. But the truth of the matter is that when you're actually on the ground doing diplomacy, it's a lot more collaborative. In general, the kind of things you do every day are the sort of things where both you and, I won't even call it the other side, but your partner in the negotiations want to achieve the same thing, and are really just looking for ways to do it. So you're in a classic mediation sort of mindset, a collaborative mindset, where it's not you against me, but it's the two of us against the problem or against the goal that we want to attain. So for example, if I was sitting in my first position in Zimbabwe, so we had negotiations, tripartite negotiations with the UN, with the Food and Agriculture Organization, and with the Zimbabwean government to set up a project, a demonstration of irrigation technologies, for example. And there, everybody wants it to happen. We want it to happen. Israel wants it to happen because they want to have the technologies displayed, possibly create a market for those technologies. The United Nations wants it to happen because it will improve the level of agriculture in the host country. The Zimbabwean government wanted it to happen also because it would help feed their people. So everybody wants the same thing. And the negotiations are very, very different than what you imagine people negotiating about reducing this number of nuclear weapons or this number of centrifuges that you have, or something like this. So over the course of those 25 years, I was definitely, something happened in my mind. My brain was rewired from competition to collaboration. After being in law school and doing articles, you know, 5 years, 6 years, whatever it is, you really get attached to this idea about winning. And that sort of winning is win-lose winning. It definitely is. We had, in those days, we had mock trial, you know, and you went there to win. You went there to beat the other side. Nowadays in Israel, there are students who, just the other week, I was judging in a mediation competition in Vienna. I was judging virtually, but an Israeli law school was taking part there, and so the students were taking part in an exercise of mediation, how to mediate, mediation advocacy, and so forth. So it's not a required course, and we will come to that a little bit later on. It's not a required course, but those are options that exist today, which did not exist. I don't want to say how many years ago it was that I was in law school, but I guess quite a while ago, quite a long time ago. So over the course of these years, these 25 years, and in that time I had the option of serving in a lot of cultures as well. I started out in Zimbabwe, as I said, but I served later on in Germany and in Turkey. I was ambassador in Eritrea. I opened the Israeli embassy in Ghana. So if Isaac is listening, I opened the Israeli embassy there or reopened, let's say, after 35 years in 2010. and in India as well. So I got to see a lot of cultures as well as working in the United Nations. So that's kind of the other side of having a collaborative nature is fine, but if you don't have the ability to empathize and to at least understand and to understand what you don't understand about other cultures, then you're in a difficult spot. At any case, at a certain point, I didn't want to work for the government anymore. I had lots of changes in my life at that time as well. And one of the things that happened during this period of change in my life, which was about a little less than 10 years ago, was that I got divorced. My then wife and I decided to separate, and me being a collaborative person and the fact that we were still good friends, we said, how can we go about doing this without without becoming enemies, because we had seen our friends and people who still liked each other getting divorced and became enemies. So a bit of research, came up with the option of mediation. And I think that in itself already begins to answer our question about the culture of mediation in Israel, is the fact that, less than 10 years ago, I was really not aware that mediation was an option for an amicable divorce. There, obviously, once we started researching it, both my ex and I said, yes, this is the way we want to do it. This is the way we want to go about this, because we will have a relationship which continues into the future as well. That is to say, we may not want to be married to each other, but we have children who are probably going to outlive us, and we're both going to be parents of those children forever. So we're going to have, besides all of the money issues and the other things, we're going to have to be at the very least civil with each other in order to both be parents of these children. I mean, and it would be better if we could even be better than that. I went through the process of mediation, and the people listening here, most of you are mediators, some of you are family mediators too. So it was, I think, fairly obvious what happened there in terms of how positive an experience it was. And at the end of the process, once we had signed the agreement, I went to the guy who had mediated in our divorce, and I said, this was one of the most amazing things that happened to me in my life. Can I learn how to do this? And he said, well, of course, I have a center, and you can learn how to do this in the center. And then from then on, basically the rest is history. My practice, I qualified, and we'll see a little bit later on what the Israeli qualification process is. I qualified, I will say, not as a mediator, but to say I qualified as somebody who is allowed to conduct court-appointed MEAMs in Israel. That is to say, mediation, information, and assessment meetings, pre-mediation stage. I did the qualifications. I never qualified because I wound up leaving Israel for Germany, and today I live in Germany. I've lived in Germany for approximately the past 2 years, and have set myself up primarily in an international commercial mediation practice, which was just starting to get off the ground when COVID hit. And then COVID, of course, it made things very much more difficult and very much easier, because I was possible to make connections and to do cases in countries which happen to be on the other side of the world. And I especially can leverage my experience in some individual countries, which is something that I do. So I maintain a law license in Israel and in the United States. I'm admitted to the bar in New York State, but I don't practice law except for a very, very specific collaborative type of law, which we can talk about at the end during the question. I always say this: I'm here to talk about mediation. I'm not here to talk about conscious contracts and about relational contracting. But you can already hear when I talk about relational contracting that it has the word relation in it, and so I will be happy to take questions about that once we move on. So what am I going to talk about today? I've already told you, but I'm going to tell you again, because it's on my list. I'm going to give, as I said, a very short introduction concerning Germany, because, as we will see, there is, for all intents and purposes, no culture of commercial mediation here in Germany at all. It's not really considered an option. in terms of solving commercial disputes. In family cases, it's a little different, but I'm not a family lawyer, so I don't really know about that. I don't really go into it. And I should say as well that I have some activities here, which I'll talk about in a moment also, but it's not really a factor there. The second subject I'm going to talk about, as I said, is mediation in the Jewish sources. Actually, to be 100% clear, it's a little bit more conflict resolution or non-adjudicative conflict resolution rather than mediation. The term mediation, as we know it today, isn't used, but we'll talk about that over the course of the past 2.5 centuries or so. And finally, I'm going to talk about the way things stand in Israel today, especially in light of new regulations and mediation regulations, which came into force on the 1st of January. And there we can, we'll see a little bit of the interplay, the dance between whether the people want mediation and the system has to supply it, or the system wants to give people mediation and has to make the people demand it or want it. So that's kind of where we stand. So first, I'm going to give a little bit of statistics, and I know we're talking about culture here, and we're not talking about math. And I'm sure Vikram is going to give me a lot of trouble that I gave a lot of numbers here, because I don't think he's a numbers guy afterwards. But I think that when you talk about mediation and the popularity of mediation and the amount which it's been entrenched into the system the statistics do actually speak. And I'm going to start with the last line. And of course, in terms of private mediations, we can't know. There's really no data on it. There's no way of knowing how many private mediations take place. That's an individual thing. But you can see here at the bottom that in fact, we are, let me get a pointer here. There we go. In Germany in the year 2019, and I'm using 2019 because it's the last year that we actually have full statistics on before COVID hit, about 13,000 cases or 13,500 cases were referred by the courts to mediation, which is 1% of the total number of cases that came into play. That is a shockingly low number. For a system which has an official referral to mediation in place. Of course, it's up to the judge's discretion whether to refer or not. And we can see here that, and these are numbers for all of Germany, incidentally, so that you're talking about 1 out of every 10 cases a judge is thinking that it should go to mediation. So it's really not a surprise that it's not becoming entrenched in the private system as well. What are the reasons for that? There's a couple of reasons, and if anybody here is aware of those sort of systems as well, I would love to have some input. Number one is that the backlog of German courts is not very great. It's about 12%. That is to say, there's about 12% carryover of cases from one year to the next. When we go to Israel, we'll see that the backlog is on the order of 50%, not on 12. And that 50% has been consistent for the past 10 years. That is to say, there are always outstanding X number of people who are not getting justice. New backlog every year is about 8%. So the standing backlog is around 12%. There's not that much pressure from above. And when we talk about Israel, again, we're going to talk about the pressure from above, from relieving the pressure on the courts and the backlog, as opposed to the desire of people to solve their cases amicably. Another reason is the average case time. You can see here for a civil case, the average case time is 5 months. When it's 5 months, you don't have any time advantage by going to mediation either. Your mediation, let's say, is going to take 3 months. A case will take 5 months. It's not in a situation like in India where Vikram has been telling us over the course of these past 2 weeks that a case can take 10 years to get heard. In Israel, a civil case is somewhere between 1 year and 2 years for a simple case. In Germany, it's 5 months. So the individual has less of an incentive from a time point of view to go for to go for mediation as well. Again, not going into the mindset. We're not talking about the mindset here. We're talking about the practical advantages that we mediators love to talk about all the time. There's another thing here, which is really, I find very telling, is the amount of cases that are settled in general, which is about 200,000. It was about 200,000 in 2019, which also goes to show you that at least in German civil cases, settlement is not as common as we find it, especially in the common law systems, like we find in the UK or in the US or in Israel, where in Israel, the statistic says, and we'll come to that, that settlement, whether it's mediated or another kind of settlement, that settlement is, cases are normally settled in about 80% of the cases. That is to say, judgment is only given in about 20% of the cases. Here, you're talking about judgment being given in over 80% of the cases. Why is that? Lots of possible reasons. I really don't know. It may be a sort of characteristic of people that want certainty, that they know certainty. It may be that the contract negotiation process itself is clearer than it is in other places. There may be a lot of reasons for that, and I'm not really going to go into it because I'm not an expert and I've only really been here for 2 years. But it gives some food for thought. And it really does go to the question when we talk about relieving pressure on the courts, getting swift justice, and so forth, and in the end getting to the place where you would get anyway if you're going to settle through mediation or you're going to settle through some other sort of methodology. Why not mediate? The effect that has on the culture of mediation, because it's just not done. And I've had conversations with very senior lawyers here, and I've said, have you tried mediation for these conflicts, whatever they may be? And, you get these kind of answers. Yeah, well, I tried mediation once 20 years ago, and yeah, we settled, but we can settle without it, and it's not really worth our while. And if the court's going to give the same decision anyway, why should we bother to go through with that? And those are the kind of answers. You get these kind of equivocal answers, who don't really see the need for mediation at all. So that's question number one to the audience, is if you have some thoughts about that. Especially, I'd like to hear from my colleagues like Giovanni, who are in civil law systems rather than in common law systems, because in the common law systems, we know the judges pretty much decide whatever they want. They do balancing, they look for reasonable things and whatever. So going into court is really a crapshoot. Whereas I get the impression that under the civil law system here in Germany, there's a little bit more certainty going into court, and therefore people are less afraid to get a decision from a judge, and they're less interested in having autonomy over the procedure. Again, that's an assumption, and I would, as I said, love to hear from my colleagues in the common law countries. So I move to the second thing, the second subject, which is the Jewish ADR traditions, and I do use ADR rather than mediation because of the terminology. When we're talking about the sources, we're talking about 3 or 3.5 different sources. The first, of course, here is the Torah, which is the original law, the Old Testament. It's sometimes called by Christians. For us, it's the only testament there is, which includes the 5 books of Moses and the prophets and the other writings that written somewhere between, hard to say, about 5,000 years ago, somewhere between 5,000 years ago and 2,500 years ago. That is to say, 500 years before the Common Era was the end, when the last book of the Bible was written. In that period of time, the Jewish people underwent a transition from being basically hunter-gatherers to being nomadic people in the desert, and to finally settling down as an agrarian society. So their sort of justice systems developed along those times. And we don't really have a lot of historic records from that period. Mostly what we do have is the Bible, is the Old Testament and the other books there. Which is difficult. It's difficult. These were written, of course, as religious texts and not as legal texts, although many of the books of the Bible are jam-packed with all sorts of possible legal things. Well, if you do this, you do this. It's not just, thou shalt not kill, but there are the punishments for killing are in there too, and there are economic laws as well as as well as criminal laws in there. But again, it's hard for us to know whether that's historic or whether that is aspirational. Maybe that's what the people who wrote these documents wanted the people to do, and it might not have been the situation. One thing that we do see in the Torah itself, in the Bible itself, is we really don't see a distinction between different sorts of judicial systems. That is to say, we don't really see that there are court systems where you go before a judge and the judge makes the decision and so forth, and other more, let's say, negotiated settlements. All of those things are there, but they're not really classified. There are examples, there are quotes you can have, but it's hard to say that it's a system, and it's hard to say that it's hard to say what the place of that sort of practice was among the life of the Israelites, again, because we don't really have any historical records. The actual record keeping that we do start to know, and we do start to see the emergence of a system, is in the Talmud. The Talmud is the second large volume of acquired Jewish knowledge. The Talmud began to be written about 100 years before the Common Era, and the first part of it was concluded about 100 years afterwards, and that was a codification of the oral law. If the Bible itself, if the Torah itself was the written law, then the oral law was codified, it was written down, the things that people knew. It's kind of like, again, for somebody who comes from a common law background, that every few years they publish the restatement of the law. And what's the restatement of the law? It has very little to do with statutes, but it has to do with all of the court decisions that have come down in the years since the statutes were written. And the Talmud is something which is kind of like that, in the sense that that the oral law was written down, and then the Talmud, of course, includes commentaries on those elements of the oral law. And the final period that I want to talk about here is the period of the Rabbinic Commentator. So once the Talmud was finished, it has the status of law as well. It is to be followed, but of course it has to be commentated, and it's commentated again through judicial decisions, and it's commentated through practical decisions, and so forth. So I want to dive into it a little bit here, what these books say about dispute resolution. And as I said, I'm going to leave it as dispute resolution because we'll see shortly that there really isn't a lot of distinction between the different forms. So the foundational document of the Jewish legal system, and not in terms of the laws themselves, but in terms of the processes and the procedures, is one book of the Talmud, which is called Sanhedrin. The Talmud is divided up into tractates. Those are the chapters. And the book Sanhedrin is the book which deals very extensively with law, with how the justice system works, with how the court system works. Just a little bit of background. Why was this necessary? This was necessary because, in fact, the Jewish people were, in the year 70 of the Common Era, were ejected or lost their sovereignty at the very least from the land of Israel, where they had sovereignty, and began to wander the world. Some in the direction of Europe, some of the direction Rome itself, some in the direction of eastward, Iraq especially, and Iran. There were Jewish communities, and some in the direction of North Africa. So the Jews scattered all over the world, and the religious and political leaders at the time, and that is what the Sanhedrin were, it was kind of the parliament of the Jewish people, decided that that all of these rules and procedures need to be written down so that a Jewish person, no matter where they find themselves in the world, will still have this system and will still have this level of certainty with them. On the one hand, it's there to preserve the Jewish religious laws, to make sure that the people don't come across on the wrong side of the deity. And then the other was to regulate the life of the community, because these rabbis had the vision to know that community life was going to become critical now that there was that we were no longer living in our land. And so community was going to be the important thing and the important focal point. So Sanhedrin talks. It gives a lot of extensive information about the judicial process, about legal proceedings. Who can be called as a witness? How can they be called as a witness? What counts as evidence? What doesn't count as evidence? All sorts of things like this. But there's really only one sort of reference to something called pshara. And it mentions pshara in opposition to adjudication. There is adjudication and there's pshara. Today in modern Hebrew, the word pshara means compromise. We use it as compromise. But the source of the word, in fact, comes from lukewarm water. That is to say, when water is not hot and not cold, or when you pour hot and cold water together, what you get out of it is a pshara. You get mayim poshrim, and so that's kind of the metaphor that they were using for compromise. It's not hot and it's not cold. We're not deciding in favor of one side or the other. Those rabbis based the idea of pshara in a biblical commandment, in the well, not in the Torah, but in the Old Testament, which said seek peace and pursue it. In other words, and not justice. And as we'll see, there's actually there's a bit of tension here between the idea of justice and the idea of peace within the community. And so that's what I have here at the beginning, this point, and I'm not going to necessarily read it, but, you know, we as mediators often have this phrase that we use, you know, we say, well, if you want, if you want law, go to court, and if you want justice, go to mediation. But these guys were a little bit more focused. Were a little bit more focused when they talked about these sort of things. And these are commentaries on what the rabbi said. And some commentators said that pshara, or having this sort of compromise or a mediated solution, if you'd like to call that, is actually a denial of justice. It's a denial of pure justice. Justice says an eye for an eye. Justice says you killed this man's donkey. You must give him another donkey in its place, or the value of the donkey. That's justice. That's pure justice. Pshara, compromise, is not justice. The other school of thought says, and here's the quote there that says, where the demands of pure justice are met, there is no peace. And the opposite, where peace is the only consideration, there is no justice. Those are two interesting ways of looking at it, and it goes back to what I said before about the value of the community. That you can have justice, but as we as mediators, we always say this when we're promoting mediation, is that, yeah, you know, you can take your neighbor to court and you can win the case against them, but you're never going to talk to them again, and it's going to be problematic that you live next to them. So you got them to turn off the radio at midnight, and you're not having any noise anymore, but you hate each other at other levels, and that's the parallel of saying where the demands of pure justice are met, there is no peace. And since the community was just as important or very important, then sometimes this consideration of peace, rather than going strictly according to the law, and the law is there. The law says you have to give back the donkey. There's contractual law. There's torts law. It's all there. But the cohesion of the community may very well be more important than actually traditional conceptions of justice. So while the original documents, the Bible itself, the Torah, talked about just justice, when community became more of a factor, then peacemaking became more of a factor as well. This also got to the point where Maimonides, who is probably considered one of the foremost commentators on all of Jewish law and all of Jewish tradition, medieval, he lived here in the common area between in the 12th century, and wrote an authoritative commentary, which is accepted by most branches of Judaism. And there he says that a judge, even if someone comes before a judge, and this is not just a matter of coming for advice or to a neighbor for conflict resolution or something, but if they come for a judge, the first thing the judge has to ask is whether you want to mediate. And if they choose to mediate, then the judge facilitates the mediation. The judge is the mediator there. And he finally closes with a comment saying that a judge who goes through his own career and has only mediated and never given a judgment, he's the best judge of all. I just want to look for a few seconds to look into the Jewish communities a little bit deeper, and to go about to talk about again this cohesion of the community. So the first thing is that communities were pretty much independent of each other. In a given area, there might be some sort of authority, some sort of rabbi perhaps who was recognized as being especially learned or especially good at resolving conflicts, or especially understanding, but there's no real system of appointing judges. You became a rabbi by ordination, and that in some cases it was because the rabbi before you said, "Okay, take over for me," or your own personal reputation, as I said, for knowledge, for wisdom, for sensitivity, and so forth. So the rabbi himself, while making, and I do say himself because there weren't any female rabbis really until the 20th century. It was all men. It was a male-dominated system. While they were there, in a way, their only responsibility was to the law, and not to any sort of organization above them who could remove them or appoint them. However, while the law was their overriding consideration, they were also commanded, and this is actually a specific commandment, to maintain the cohesion of the community. And therefore, when you had a situation which required some alternative practice to be used in order to not let the community break apart, that would probably be done. And we do see over the course of Jewish history in the past 2 millennia, from the beginning of the first century CE and until the 20th, even to the 21st century, the Jewish communities are constantly splitting and coming back together and splitting and coming. Often it's based on theological grounds, but in other cases it's not theological; it's personal. I want to go with this leader, and you want to go with that leader. Sometimes it's just a split within the community. So one of the critical jobs there of the distributor of justice, as it was, or the dispute resolver, if you want to call them that, was to try to hold the community together within the confines of the law, however. And that's also a little bit similar to what we do as mediators. If our clients want to have a mediated agreement, which also involves the exchange of drugs or something, we're going to have to say, well, no, you can't do that. That's illegal, and it's an illegal contract, and I can't sign off on that. So here also the law gives you the framework, but again, as long as what you're deciding is not illegal per se, then it's within the realm of possibilities. One thing which is noticed down through the ages, and the truth is things became pretty static until the end of the 19th century. That is to say, Jewish communities lived alone, isolated, had their religious leaders resolving conflicts however they saw fit to resolve conflicts. But that is to say, they could do it by adjudication, as you saw in the Maimonides comment from earlier. They would probably come to the same person, rabbi, judge, whatever you want to call them, and say, "Here's my conflict." The two neighbors would come to them, say, "Here's my conflict," and then, of course, that judge, and this is going to become critical in what I say later too, that judge would then be instrumental in saying, "Go mediate" or not. One thing, however, is that while the cohesion of the community was to be maintained, the documentation that we have of dispute resolution procedures over the course of those 2,000 years don't really show anything about what we would call transformational mediation today. That is to say, about growth of the parties, about really teaching the parties. It's more about interests, about realizing the interests, and as I said, not only interests of the individual, and not only the interests of the religious institutions, but the interests of the community as well. And I'm going to jump forward now. I'm going to be jumping forward about 2,000 years to the modern state of Israel. What I did mention there is that system, pretty much the system that I talked about, pretty much held up for until the end of the 19th century and even into the 20th century, as Jewish communities were being integrated at the end of the 19th century into the rest of their countries, into the rest of their countries' lives, mostly in Europe. I have a kind of Eurocentric approach to this because that's the tradition I come from as well. But once in 1789, when the Jews became French citizens, or in 1848 when they became German citizens, at that point their own justice systems became largely irrelevant. If you had a dispute, you had to, and you would do it in a civil court of that country. Of course, if you had a personal dispute, you could always go to a rabbi, to a wise person, to have them help you resolve your conflict. And to a certain extent, that still happens today among more religious people, I would say. And the more secular people, if they were in that situation, they would most likely go to a mediator. So this would be the entrance of modern dispute resolution onto the stage, would be when Jews became integrated in civil society, end of the 19th and beginning of the 20th century. The state of Israel was established in 1948. Based on the British law system. Israel was a British colony, and as such inherited, the way most British colonies did, inherited the British legal system. From then on, of course, it's developed in differing directions. Again, we see that in the United States, we see that in India, we see that in Ghana as well. Countries that were British colonies developed their own legal system after gaining independence, and that's what happened. That's what happened in Israel. But Israel was burdened for many years with, I would say, this kind of British bureaucratic tradition of old paper files and judges. The judges don't wear wigs, and the advocates don't wear wigs in Israel, but we do wear robes. Everybody wears robes. You know, that's not something you have in the U.S., for example. And that made the system slow, and it made the system unwieldy, and the wheels of justice turned slowly, and so forth. And that kind of helped get us into the situation that we found ourselves, especially in the 1970s and later in the 1980s, with this massive backlog. And I'll have some statistics on that in a moment. Towards the end of the 90s, the Chief Justice of the Supreme Court decided, really as an individual, to try to bring mediation into the Israeli judicial system. And interestingly enough, he wanted to do it from a position of the value of mediation, and not because of relieving stress on the courts. You would think that as the Chief Justice, his primary consideration would be relieving stress. But here we have a quote from an article from Professor Mordechai Moroni, who's one of the leading experts on ADR in Israel. And he said the reason that he wanted judges to impose mediation was to use their high professional status and prestige to teach the disputing parties and the litigation bar about the value of mediation and its promise, to use judges as educators and agents of change in the ailing Israeli culture of disputation and dispute resolution. So he goes on to say in that kind of quote, that the release of back pressure, the release of the backlog on the court system, would be the way it was sold to judges. But the actual ultimate goal was to realign the way that the Israeli system thinks about conflict and thinks about conflict resolution. That was his real motivation, and you would tell the judge it's a good thing to do because it would release their back pressure, and here you can see this kind of idealistic view of judges actually becoming the primary advocates, the primary salespeople of mediation. That was that quote was in 1999. The truth is that mediation didn't really begin to take hold in Israel until much later, until in the mid-teens or so. 2014 was the first obligatory law in family law. And today, when we speak about it, and we're going to talk about the regulations in a few minutes. But today, when we speak about the justification, the rationale behind mandatory procedures, mandatory Mayan procedures, the objective is to decrease the backlog and to increase access to justice, but not to have a transformation in the dispute culture, let's say, of Israel. So I'm going to go here to a number of questions which I ask myself, and I'm not sure that there are answers, but again, they're questions for you to help me out with a little bit. And the first question is, and this is before we go into discussion of mandated procedures, if mediation were an integral part of our culture, that is to say, the Israeli culture, if we thought of mediation before thinking of anything else, or before thinking of litigation, would there even be a need to mandate in the first place? And even beyond that, would there even be a court backlog? If people were going and solving their disputes amicably, cooperatively, collaboratively out of court, there probably wouldn't have been a backlog in the first place. So those are some questions, and the follow-up question to that, of course, is if the answer to those is negative, no, there wouldn't be a need to mandate, and no, there wouldn't be a court backlog. Can the mandates actually create that culture? Can they do that in the reverse? And I think there are strong points in either direction. We can talk about that a little bit more. I think our experience in family law, for example, would say that maybe yes, that more family disputes are mediated because there was a mandate there, and that now people think of mediation first, or maybe no. I'm just going to go through very, very quickly some of the assumptions that I make when I'm talking about the new Israeli legislation. The first one is an assumption that mediation decreases court backlog and it prevents semi-frivolous cases. I think that can be argued statistically too, whether it does or it doesn't. Second assumption, mediation can't be imposed. And if you notice that up until now, I have not used the term compulsory mediation. I haven't used the term mandatory mediation. I've only used the term mandatory Mayan because mediation is voluntary. We all know that. We learned that on the first day of our mediation courses. So you can't impose mediation. You can make the guy show up, but you can't do anything more than that. And Israel does make the guy show up. There's a fine for not showing up. And another point, which is sometimes overlooked, but is really necessary there, which is if you have mandated Mayan, let's say, and not mediation, or mandated requirement to show up for mediation, there has to be some standard of qualification for mediators. If you're going to, the two are dependent on each other. You can't say, okay, go and mediate. You have to go and mediate, and there's a judicial sanction for not mediating, but you can go to whoever you want. That's not really a possibility. That doesn't necessarily work. On the other hand, it seems counterintuitive to say that people can be prevented from mediating at all. As I love to use this example, that the minute your children are arguing over the last piece of cake and you say, let's sit down and talk about this, you're mediating. And of course, you don't need to be licensed to do that. You need to be licensed to drive a car no matter what. But you don't need to be licensed to mediate between your children, and you don't need to be licensed to mediate between two companies who have nothing to do with the courts. So that creates an interesting situation. And in Israel, the solution that was found, which is there are very rigorous demands for training and for experience and for qualification, but those are not to be a mediator. Those are not to call yourself a mediator. Those requirements are requirements which are to be on a court-appointed list. In other words, for the court to be able to appoint you as somebody who is a Mayan facilitator, then you have to fulfill certain requirements. So I gave you the German statistics. Now I want to give you the Israeli statistics. And for those of you who saw Racheli's talk last night, where she talked about 500,000 new cases, that was a little bit old statistics. In truth, the number of new cases in the Israeli courts now per year is about 850,000. Now you can see, excuse me, that 880,000 are closed every year. So you would think the backlog would get smaller, but it doesn't. The backlog is also staying pretty stable at just under 500,000 cases. You look at it, it's over 50%. So if we talked about a backlog in Germany of about 12%, you're talking about in Israel, a backlog of 50%, 50% of cases. Time for your case notwithstanding, it means that if you submit a case, there's really only a 50% chance that it's going to be solved this year. And only a 50% chance that it's going to be solved in any given year. Average time to close a case in the courts of first instance in Israel in civil matters, 12 to 24 months, as I said before. As I said 80. My slide proves me wrong. It's about 85% and without a judgment, with settlement. About 50% of the cases that are sent to Mayam, and we'll discuss that in a moment, which cases are sent, continue on to mediation. And out of those cases, about 60% of those mediated cases end in a mediated agreement, and another 20 eventually settle. And again, we mediators like to believe that that's because we taught the parties during the mediation how to actually talk to each other and then made it easier to settle. Here you can just see the yellow area down here is the backlog. So you can see the backlog pretty much stayed steady no matter what the caseload was on the courts. So just to visualize about the amounts of cases and the way it's going. So if you look at the outer circle is the total number of cases. Here, 80% of those cases, or 85 in fact, settle in one form or another, whether mediated or not mediated. Out of the total cases, irregardless of that 80% settlement rate, 50% of them, all of these cases basically are sent to Mayam. Let's be clear about that at this point. Almost every civil case is sent to Mayam above a very low threshold. Over those cases which are sent to Mayam, 50% continue on to mediation. Out of those 50% that continued out of mediation, 80% of them settle eventually. So that's 40% of the total cases. And those that reach a mediated settlement, as I said, is 60% of those 50%. In other words, 30% of the total number of cases are solved in a mediated settlement through the Mayam system. That's basically the way the numbers work today, again, for civil cases. So what is the Mayam procedure? The Mayam procedure is any case over a certain level. Sorry, there we go there we go. Whoops, got to go back. Any case over the value of about 10,000 euros, it's 10,500 euros, needs to go for Mayam. This is under the new regulations, as I said, which came into effect on the 1st of January. Up until then, there was a pilot program running in 2 courts, in the district court in Tel Aviv and in Nazareth. But now it's across the board in the magistrates' courts and will eventually be expanded to the district courts. In any case, so for a minimum amount of any case which is greater than 10,000 euros, you have to go to Mayam. Mayam is a meeting where you sit with a court-appointed official. And as I said, the court-appointed official is a mediator. It is somebody who has been trained as a mediator, but it's not defined as in a mediation session, where they explain to you the benefits of mediation. They analyze the case maybe to see whether it's appropriate for mediation. And this kind of thing, it's the thing that Vikram hates, also is free. It's free to the parties. They don't have to pay for this, but they don't mediate. They then, after this meeting, which lasts somewhere between an hour and 90 minutes, usually, unless of course the parties are both experienced in mediation, that they've mediated cases before. They then have to make the decision: are they going to go continue with mediation, or are they going to go back to court? And that's where the 50% comes in. If we look back at that 50% there, 50% of them say no, let's go to court and take our chances. The other 50% say, okay, no, we're going to try to mediate this. At that point, they have a decision to make. They can decide whether they're going to go with a private mediator, which they can do, that is their right, or whether they're going to continue with the Mayam individual who at that moment changes his hat from being an information source to being a mediator. And at that point, he can begin to charge them. Not a lot. It's about 100 euros per side per hour. That's fixed by law, how much you can charge if you got the case through being a Mayam mediator. And then that case goes down, and it's mediated like any other civil mediation. Again, the parties could go to a private mediator if they want. There, they would probably be paying a lot more than 100 euros per side to the mediator. So that's kind of it's kind of a mixed blessing in terms of encouragement. However, and here's the kind of important thing about that. What seems to be the case, and this goes back to what Justice Barak said in 1999, is that the best advertisement and the best marketing for mediation seems to be experiencing mediation. I mean, it was for me, so much so that I decided that I wanted to become a mediator. Not only that I would mediate my disputes, but that I actually wanted to do this for a living. And if almost every civil case you have puts you in front of a mediator at some point or another, then you're likely, as a lawyer, as an attorney, on the one hand, to say, okay, mediation is an option. It may not be my preferred option, but here is something which it might actually work for. And second of all, you are likely to think highly of the mediator that you sat in front of, which is why it's so desirable to be on that Mayan list. Why it's desirable, even though you can mediate really without any kind of training or any kind of qualification or any kind of process, why it's so desirable, because the court feeds you cases which you don't make a lot of money on, but the lawyers there say, okay, this guy is a good mediator. Maybe I'll go back to him, not as a court-appointed mediator, but as a private mediator in the future. Again, whether that's valid, as mediators, Israeli mediators, we do believe that is the primary reason for doing these mayams, is to get your name out there and to get people to know you and to get people to think you're good, so they can give you word of mouth recommendations to their colleagues as well. So that's basically the situation in civil. Because I have only 10 minutes left, I'm not going to continue. So I'm going to leave time for some questions.
Please take your time. Please take your time.
Okay. No, but you see, my clock is running here. So
no, your clock is not running. Your clock is not running. Please, last session, that's the advantage. We want to hear you.
Yeah. And I'm just not going to talk about family. The one point I want to make is a point that I made in our conversation yesterday when we were talking about that, which is in family cases, except for some very extreme exceptions, when there's danger or when something needs to be really done immediately, all family cases have to go to Mayan first. And there they have a very kind of interesting setup, which is that first of all, if you go to court and try to submit a complaint in a family matter, divorce, child support, maintenance, alimony, things like that, the first thing they will do is they will say, thank you very much. They take your papers, they take your court fee, and they send that paper to a mediator, even if you want them to or not. You have to sign it, obviously. So it goes to a mediator before a judge, before a clerk ever sees it. You have to do that. And if the other party doesn't show up for the mediation, again, there are sanctions against them. There are sanctions. That sort of Mayam is a bit different from the commercial Mayam. First of all, it's 4 sessions. Second of all, it's very structured. The first one is with a mediator who is a social worker. And it's only with the parties, it's not with counsel. Under certain circumstances, you can take counsel with you, but that meeting is basically with a social worker without counsel. The second meeting, and as I said, you are required to show up for 4 unless the mediator says, okay, there's really no point. The second one is with a mediator who is a lawyer, a legally trained lawyer, a legally trained mediator, and you can have counsel at that meeting as well. And that's usually where the decision is made, whether we're going to mediate this or whether we're going back to court. And the mediator writes a report of the Mayam saying whether this case is mediatable or not. And if it doesn't seem to be, if there's no consent, there's no voluntariness on the part of the sides, or if the issues are something which really need somebody to actually decide on, a judge must say one way or the other, or if there are questions of the law being broken, then it can be sent back to the judge. And so with this situation, which has been around since 2014, that obligation has been around since 2014. Again, it was piloted before that, but that's pretty much been the situation, that in any family matter, whether it's taken to a civil court or a religious court or whatever, has pretty much brought around the situation that in a lot of cases, you look at websites and Facebook pages and LinkedIn pages of family lawyers, the option of mediation is pretty much always there. It's become part of the culture, if you will, of resolving family cases, not commercial cases, but family cases that, once again, any family lawyer for any case that they've been doing, it's now come up. They've found their clients in a situation where they have to go to Mayan. They have to be exposed to mediation. So it's already become the point where they mention that on their websites. They advise their clients concerning the advisability of mediation. They must participate in Mayan, but whether they should mediate afterwards. And in fact, quite a number of family lawyers themselves have undergone at least the basic training as a mediator, not necessarily the extensive advanced training you need to become court appointed, but at least to do the basic course, which in Israel is 60 hours. And then family is another 60 hours. So it's a basic training of about 120 hours. To be a family mediator, and quite a number of family lawyers have done that. So that raises the question: is there now a culture of mediation in family matters? There's a procedure. It has been required by the court, but can we say that within less than 10 years, this having been required over and over and exposing the lawyers to it, has that made it part of the culture? And I would venture to say yes, because, as I said, it's not seen as a necessary evil by most of the family lawyers. It's seen as part of the process. It's seen as something which might be recommended to a client in appropriate circumstances. Whether you're going to make the change, you're going to say appropriate circumstances are 100% of the cases, whether appropriate circumstances are 20%, if you're going to advise your clients that way, that remains to be seen. And that would probably be a better metric for how deeply mediation has been inculcated into the legal culture of family matters. But that's family, and for commercial matters, it still remains to be seen. As I said, these regulations are very new, and the approach of the people who drafted the regulations, and I've spoken to some of them, in fact, the people who were involved in drafting the regulations, the approach was definitely to relieve the strain on the courts. They did not care about creating a culture of mediation. They did not care about creating a culture of accommodation and of collaboration. That wasn't on their plate. They were aware that that's an advantage. Obviously, these aren't callous people. They're not machines, but they weren't really necessarily interested in doing that sort of service to the system. There's a lot of interesting discussion about why. I'd just like to add to that point that there are some fairly obvious pointers to the fact that that's what it's for. For example, a new stage in civil procedure was added, which is before you ever see a judge, there has to be a preliminary report where the parties, among other things, report on whether they have considered ADR, not necessarily mediation. It could also be early evaluation. It could be conciliation. It could be even arbitration. Have they considered it all? And if not, why not? And if they've decided against it, why not? Sounds like a decent thing. However, there are some really telltale suspicious signs there. Suspicious sign number one is that it's at the same meeting where they're supposed to whittle down their pleadings and to get to only the real main points that have to come before the court. It's a time-saving matter. It's about time saving for the judge. The second suspicious thing is it's only counsel. The parties don't even take part in that meeting. So how are you going to be going to an approach of interests? And I mean, we of course all know how important it is to have the parties in the room. They may be represented, they may not be not, but to have the parties in the room. The fact that it's just lawyers talking to lawyers, again, makes it a little bit, it doesn't make it suspicious, but it points out the fact that it's about saving time for the court and really nothing else, and not necessarily for the welfare of the parties. That's stage one. And stage two, again, a few weeks later after that, the court will order them to go to this mandatory Mayam. And then they go through the whole procedure that I talked about before. Even when they come back at any point in the proceedings, the judge is allowed to, and in some cases encouraged to, refer the parties to mediation. Once again, it's voluntary, but you do have to show up, and you have to show up in good faith. There's some case law. It's not 100%. The guidance isn't 100% clear about whether you can just show up and say no, 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 and go. not 100% sure yet. But you do have to show up in good faith, at least to listen to what the mediator is saying in the Mayan before you make your decision. So that's point number. So touch point number one is this preliminary meeting. The touch point number two is Mayan, and touch point number three, the judge, and not only the judge, but also a legal assistant, a legal clerk, can suggest that the parties go to mediation, and that suggestion goes on the record. You can't be penalized for not going to mediation, but obviously when the judge suggests something like that, then that has to be weighed very, very heavily by the parties. Of course, it comes down again to the question of the judge. Does the judge think there's any value in mediation or not? I'm just going to close with, I hit you twice with statistics. I can't hit you a third time with the statistics I want to give you, which is how successful has this program been, because it's only been in place for 6 months, and it's only been in place for 6 months under COVID conditions, and there really aren't any statistics on that at all. And I think we'll have to wait 5 years, 10 years to see how that works. But once again, going back to those questions, and that's the question for discussion, which I mentioned before, is that do you create a culture of mediation by mandating or not? Again, I would have said no. I would have said 100% no until you see the experience with the family law, that there is some sort of transformation that happened. There is some sort of click that happened in the consciousness of the family lawyers, and it's not just because it's written down they have to do that, but they do see it as a possible and in many cases a preferable option. So I will end with that, and I will open it up to questions. And once again, really thank you, Vikram, for letting me talk interrupted. I think this is the longest you've ever let me talk interrupted in one of your forums. So it's been a great opportunity.
This is what I always say. This is that one opportunity, that one chance, very rare chance that someone gets to talk so much when I'm there. Okay, but so basically, in terms of question, in somewhere here that you said that it could be conciliation. Can you just elaborate on that? It could be conciliation is a little different from the mediation as what you put across.
Right. Okay. Well, what the law it says, and again, this is in commercial matters. What the law says is that the parties must submit to the court a report of how they considered ADR. Okay, and if they rejected ADR, why did they reject ADR? So in this report, and it's supposed to be, again, it's a very new thing. This is something which has only been running for the past 6 months or so under COVID conditions. But I don't think there's a lot of experience yet. If you can just write one line, we considered mediation and said no. This case isn't relevant for arbitration. The court, I will, if you give me a moment, maybe while if somebody else is talking, I can look up to see what the exact phrasing is. It's phrased in Hebrew, so I'm kind of translating it on the run. But one of the things that is mentioned is that it's not merely mediation, that it is the range of ADR. I want to see how that is spelled out specifically.
Because while you're looking at it, I'll explain to you how it is in India. So the court has the option, again, the ADR option. So in that there is arbitration, mediation, and conciliation mentioned there. So that conciliation is when you go out of the court system, there is an Arbitration Conciliation Act. So there is conciliation provided there. You do it there. If you're successful, that settlement agreement under that act itself is a court decree. So you don't have to come back to the court. Doesn't get settled, you come back to the court and get into the court process. So that is the conciliation mentioned there. So in your case, do you also have a separate law on conciliation?
No, we do not. That I can say we don't have any separate law. There are certain laws concerning. There's obviously an arbitration law, and concerning mediation, there are certain references to it in the court's law, especially the things which provide for immunity and privilege and so forth. Those are in the law, which I actually have a slide on, but it's not really important to talk about that right now.
Always important.
And so
everything that you have to say is important.
Yeah, but so there are those things. Those things are the things that are mentioned in. I have to do a text search here while we're talking. So those things are mentioned in the law, in primary legislation, an act, basically. Then the rules of mediation, when it is either court, when it's required Mayam, in other words, mediation which has gone down because of, as a result of a Mayam meeting, or when the judge has said to you, go mediate, then there are other rules which apply. For example, the mediator coming from the mediators list. All of that's in the civil procedure regulations. So that's where that comes. But in all of those things, the term, let's see, I'm just looking at what the report has to include.
But
Says,
we've always
yeah, no, I'm just saying to see what
No,
it says about.
please have a look. I'm just saying by the time you look, you can definitely multitask. I know you, so you can keep looking at it. But I'm saying that whenever we talk about mediation, always ends up talking about the court system. Is there private mediation? Is there a law there? Anything on that side?
No, there's no law there. However, first of all, in terms of freedom of contract, it's a contract like any other contract. And this, we can come to another point which I didn't mention. Israel is a signatory on the Singapore Convention. I should mention that it hasn't been ratified yet. Private mediation, again, maybe I should have said this explicitly, but the whole idea of boosting, when I say boosting mediation, I mean boosting private mediation and not boosting court-appointed mediation, because now court-appointed mediation, or at least court-appointed Mayam, is obligatory. That's not an issue anymore. If you go to court, you're going to go sit in front of a mediator for an hour. The question is do you go to the mediator beforehand? And it is done, I would say, mostly in international cases, where the advantages of mediation in international commercial cases are clear. You don't have any of the issues that you have with arbitration or with adjudication. So in a lot of cases, that's where it's used. I know of a number of mediators that I work with. Some of the people I've trained with do private commercial mediations, and this is the case, I think, in a lot of places where you're talking about private mediations, even where it's developed, it's often in the hands of a few kind of very famous mediators with a very high reputation, maybe the background that they were a judge once, or they were a professor of conflict resolution, or they were a leading businessman, or they were a very, very senior lawyer. And that you can count. And Israel's a small country. We may have 800,000 civil litigations a year, but you can still count the number of those guys. I don't know if on the finger of one hand, but on the fingers of two hands, probably. So if you're in big business, you're doing business with a major overseas company, and I don't know what, you're buying parts for automobiles or something like that, and it's it's $1 million case, you're probably going to go to one of those big 10 for private mediation, but you will probably go for mediation and not for litigation. I don't know how much I would call that a culture of mediation, though. Again, that's for some very specific economic reasons that you do it. And not because you think a collaborative solution is the best, not because you're not adversarial. You do it, again, to save you money, to keep yourself out of the courts, to keep your intellectual property secret, whatever it is. But it's not because you're collaborative at heart. And I think what people like kind of you and me are getting at is about that, about solving disputes through communication and through understanding and through examination of needs and interests, and not just because it happens to be confidential.
Well, I'm just thinking that we keep talking about the culture of mediation. I think we should start discussing the culture of litigation, because when I see that you have a population of 8 million and you have 800,000 cases, that's 10% of in terms of population, 10% if you look at it. India, if that happens, you can understand how many cases that would be if that happens in India. We're a 1.3 billion population. So you can understand what that would mean. So where is the problem? Because I'll tell you why I'm relating this to also the US situation, that very high number of cases going to court and mediation being there for so many years. So is it that the culture of litigation is what we have to start hitting at, and why is that there? Do you have any idea? I mean, if you spoke to people, and what do they say? Why are there so many cases?
I don't. I don't know. First of all, I don't know. And second of all, Israel is definitely a litigious society. Like you were saying about the United States, again, I don't know how the statistics compare between Israel, the per capita number of suits that you're talking about. I don't know how it compares to the United States, but I think it's also similar. It's also very, very high in any case. It's ridiculously high there, and it's ridiculously high in Israel. Because it's hard to say. There's a question of, there's a kind of matter of an ethos that I don't know if it's a matter of running off to a big parent who's going to decide for me. You can't do that to me, I'm going to decide. Whether it's the desire to be heard, I don't think it's necessarily about the desire to be heard, because once if somebody has been exposed to the option of mediation, so the mediator hears too. They don't hear as a judge, but they do hear. And more importantly, the other side hears, that the three of you are sitting around the table. And this person says, yeah, I did this and I felt that and whatever. And so if you're a decent mediator and you give the person some time to express what they want to express and to say what they need to say before getting on to solving this problem, but just saying what they need to say, that's let me just give a kind of small example here too, which is that small claims courts refer cases pro bono to mediators. It's all pro bono. You don't get any money for it at all. As a matter of, when you're doing your mediator training, you have to do at least 6 cases of these small claims court cases that come to you. And that's referred as a matter of course. The judge says, do you want to mediate? They all say yes, because why? What do they know? They don't know what mediation is. The judge doesn't explain anything. It's a matter of 1 minute. Would you be willing to try mediation? Yes. And then you as the mediator have to call them and kind of explain to them what mediation is to get them to come in the first place. And at that point, they say, well, you're just going to split the difference between me and the other person or whatever it is. I don't want to do that. And then when you say to them, no, you're actually going to get a chance to make a statement. You're going to say whatever you could say before a judge, you can say in front of me. Then that's a lot of times, that's the thing that convinces them to mediate, and not, again, not the speed, not the cost, not the confidentiality, all of these things, but just the ability to be heard. I think, but a lot of people think the way you get that is in front of a judge, because a judge has to sit there and listen to you. They don't realize that the judge also, in a lot of cases, cuts you off and says, no, I don't want to hear that. Just tell me, get to the point. How much did the car cost? How much did you have to pay for the accident? Rather than, getting out. But people think that here I can go before some parental figure and have my say, and then somebody has heard me. Dad has heard me, mom has heard me, God has heard me, whoever it is. That's a big deal, and people have to know that they can get heard in mediation as well. And that's something that a lot of mediators don't sell as their selling point. The fact that somebody is going to hear, not only is somebody going to hear you, the other side is going to have to look you in the eye when you're talking to. And that's really important. That's really important.
Okay, so I just want to show you this worrying part that I see, and then let's discuss that part. When I do a Google search, what does it show me? If the cases in the US, it says 100 million cases. Okay, and it's a 350
million. Yeah, it's
exactly.
the third. It's a third of the population.
So what I did was, where is it coming from? So I said, let's just obviously open the next thing. Where is it coming from? It comes from this report. Okay, this shows more than 100 million cases are filed in each year. Okay, this is a report. I'll take you where this report comes from. So this is where it comes from.
Okay.
Okay, so this is what it looks like. In such a situation, if this is what we see, where are we getting at in a country where we say that 40 years in mediation, and they are taking this to all parts of the world, and people think that is the model that we have to pick up in our court system and everything. So, are we just following something which hasn't worked the way I would think it would work? The whole culture of mediation as such in that many years, if you've experienced it so much and you don't still believe that this is the way you have to go, and you have to go through the court route, is court just a threat? Is it just a threat in Israel and in the US, so that finally it's the lawyers there who then take it through mediation? So how does it happen here also?
Remember the statistics that I showed you in the Israeli courts as opposed to the German courts. In the Israeli courts, 80 to 85% of the cases settle.
Yeah.
With or without mediation doesn't make a difference. So if those cases are settled, then in a way, if you look at it, and you can say court is scenery, or court is a threat, or court is something because we're going to talk it out in the end anyway. And in 85% of the cases, we're going to shake hands on it one way or the other, with mediation, without mediation, whatever. Whereas in Germany, for example, only, what was it, 12% of the cases settle? So if only 12% of the cases settle, court is a serious thing in Germany. And that's also maybe why you don't have a culture of mediation here at all. Because people don't settle. People go to court. People wait for the decision of the court. And the courts here are very efficient in dealing out, I'm not going to say they're dealing out justice, in dealing out decisions. The courts are very efficient. 5 months, and it could be a 200 million euro case, 5 months and you're done. And you're not encouraged necessarily even to settle. You're encouraged, you're asked if you want the option. So I think there's something to that. I don't know what the settlement rates are in the United States, but I think they're similar. I think they're way up there. They're in the 80s, like in Israel. I don't know what they are in India at all, but there's definitely something to that. That court is the threat, not the threat of litigation, not even the threat of litigation, but the actual litigation, actually going, submitting the papers and everything in Israel is part of this dance you do that everybody knows at the end is going to wind up in an agreed settlement out of court or with court approval.
Yeah, so to say that many cases get filed in the court, actually not really being filed in the court, it's just being put there so that, okay, now let's sit on the table. So that's what it's all about. That's what it appears to be. So I think, but because I'm just saying, when we talk about mediation, developer to mediation has to come in when definitely people are not looking at the court as an option at all, and to go there at the first instance, so that it's not really, I'm doing this, like the word being used now is pre-litigation. I'm saying it's not pre-litigation. Litigation is not in your mind. You're sitting there because you want to mediate. So is that pure thing ever going to happen? Are we getting it there anywhere?
It's really hard to say. If you remember at the very beginning, I talked about my doing relational contracting, or conscious contracting is called to, which is about that. It's about writing into the contract things that you and I would probably recognize as mediation techniques. First of all, without a third party, but to start the escalation by saying the first thing I want to do is I want to write down in my contract what my interests are and what my needs are. And the second thing I'm going to do is, when there's some sort of conflict brewing, I'm going to read that I signed 5 years ago. Who goes back and reads a contract that they signed 5 years ago? But I've required under the contract to do that, to go back and read that. And the third thing I'm going to do is I'm going to pick up the telephone to the other guy, not to my lawyer. I'm going to pick up the telephone to the other guy and say, hey, we need to talk about this. Remember 5 years ago what we were talking about then? Why are we in this business together at all? Why are we in this relationship? Why did I hire you? It can be an employment agreement as well. There's a lot of employment, workplace mediation. And that's what relational contracting is about. It's about getting those things and creating a way to talk about those things. And then eventually, if you can't do it alone, you can't do it one-on-one, then bring in a mediator. But the court is the absolute last step in the process. You can build that in such a way that they have to go through the process. They have to go through the process of talking to each other. And if they can't talk to each other because they hate each other, whatever, then bring in a mediator, but don't go to court. Do not go to court. It's pretty out there. Okay. It's pretty, it's considered pretty radical, pretty innovative. It's not a very common way of writing contracts. But I believe in it. I really believe in it. And that's, I was out of practicing law at all and was only into mediation. But then when I saw this thing and I was saying, it's like pre-mediation, not pre-trial, but it's pre-mediation. It's getting the people to think in this sort of way that we're talking about before they even wind up signing the contract with this other person. And I think it has a lot of potential. I think it definitely has a lot of potential. But if mediation needs a lot of work to convince people, this stuff needs even more work to convince people that it's worthwhile.
No, but you touched on colonization. I think we need to, of course, look at that as what is the effect of that on generally on collaborative dispute resolution. I think that I haven't elaborated too much on that. If you want to do it, we can do it, and that's a special session that I'm saying that I'm going to do on that. So we'll definitely do it. But one thing interesting that comes up, Chuck, is that we keep saying so many % of the cases get settled. But at what stage are they in the court process? Do we have any idea on that?
No. I
Yeah.
do not know. I know in the US that's a critical question. Because of the cost of discovery. And I've never practiced law in the US. I have a US law license, but I've never practiced there. And they say the discovery is the big thing. That's what takes the time and the money and everything like that. And I know there's a lot of argument among our American colleagues there about whether mediation should be before discovery or after discovery, or settlement talks should be before discovery or after discovery. I don't think there's any statistic on that too, because also, I mean, there's a lot of settlement talks that don't ever reach fruition. And then you're not supposed to talk about them in court. Nothing that goes on there may be mentioned. You can say we had settlement talks and either they worked or they didn't work. You can't really say anything more than that.
No,
I don't know. I've never seen any statistics on that. It might be the kind of thing that somebody might do empirically, like as an academic. And the bureaus of statistics and the court systems are not going to be publishing that sort of thing. An academic, maybe somebody doing their doctorate, is going to try to collect that sort of information. At what stage?
Because I'm just thinking
I've never seen anything like that.
Yeah, because if we are looking at so many cases get settled when they're in the court, then are we saying that the cost of that litigation starts at that stage? So they're doing it before that. So, so are you going to then maybe the entry into the courts, are you going to make that higher? The cost of entry into the court so that they do it before that? I don't know how. Is there a...
Should we stop recording here now?
At any point of time, if Giovanni had something, I would have wanted.
We can leave that recorded. Yeah.
Yeah, I would love to have that recorded. Giovanni, anything that you want to comment on? You want to put it in the chat, but always I like Giovanni putting in the chat first.
First of all, I would like to see 2 slides that disappeared just in half a second about the qualification of mediators and. Well, qualifications general, and also the different kind of mediation that you have in Israel. Anyway, I think that you will share your slides with Vikram and he will send them to us. It's okay. First of all,
I can just. Is this is qualifications? Wait, I'm just looking for the qualifications. Here I can show you that.
Yes, because also, especially in the new way, just the new procedure civil code that we come in force now in 2021, the training is crucial, I think.
Yes.
So it's very interesting because we have, according to me, in Italy, the big problem is the poor training. It's okay, just qualification general. Okay.
Yeah. So these are the qualifications, which is this is for a civil mediator. For a family mediator, there's more requirements on top of it.
This is for family mediator?
No, this is for general mediator, for civil, workplace, whatever. Okay. So you need an academic degree and you have to have 5 years of professional experience. In other words, not just coming out of college or something like that. To the basic course is 60 hours, which is it's theory and role plays, but not actual mediations. Then afterwards, you have to do the practicum, which is another 60 hours of course, plus 6 actual cases under supervision.
So 120 hours of course.
Right. And then and so those actual cases are under supervision. It's the students are either co-mediating or doing solo mediations. For that, then you need further experience to be on the list. This is all qualifications you need to be on the list. Yeah, not to call yourself a mediator or whatever. Whatever. So to be on the list, if you want to be on the small claims list, you need 6 cases. So actually doing the course is enough to be on the small claims list, and you need 18 cases if you want to be on the full list.
Summing up, except family mediation, you have 120 hours theoretical and 30 cases.
No. You have 6 cases. You only have to be on the list for non-family. You only 18 cases, not 30 cases, just 18 total. In other words, the six you do in the course plus another 12 you have to do on your own.
That's
Okay,
okay.
That's
okay.
Yes.
Now I think Giovanni, I'll just mute you. One sec, Giovanni, I'll just mute you on this because he will not let me finish on that. But basically, what Giovanni always keeps saying, training, 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 and I keep saying that first of all, which jurisdiction are you talking in? If you're talking in a place like ours where there's 1.3 billion people and you do not have any private mediation developing, court system does definitely, there is work happening there. But if we really want to train, who are the trainers? Are we talking about their qualifications? I never see that in any discussion that happens. No one shows me a slide saying the trainers are required to be this X, Y, Z. That doesn't happen. And numbers that we need. How will first of all, I think we've always never been discussing. I've always been saying it, but I've never got any inputs on that. How many mediators do you need for every 1,000 population?
There's a very interesting point there, which is sometimes what I call the ethics of mediation training, which is a lot of institutions, and this is not in Israel, this is just from my experience now, especially in the virtual world, being part of the mediator community, whatever. A lot of institutions say, hey, we're going to train you for this fantastic, wonderful new career of dispute resolution. And if you're a peacemaker at heart, come do this course and whatever. And I think, most of the people who run these courses know that there isn't enough market to sustain all those mediators. Yeah. Having said that, I think that training people in this way of thinking and collaborative thinking and in nonviolent communications and in active listening, training people in these sort of things is fantastic. The more the merrier. I wish everybody in the world were trained these things in elementary school.
Exactly. No,
but training them as mediators with the promise of having making a living from mediation, that's a little bit unethical.
Yeah. No, what I'm trying to put across is even like every Marzana was also talking about peer mediation. No, but whenever I see all these programs, finally it is about non-violent communication and how you should deal with each other, all those things. I don't see too much on the fact of the mediation part of it, because finally at the end of the day, you want mediators out there. The fact of whatever you want to put across in terms of literature, in terms of non-violent communication and everything, you can do that. I mean, there's so many ways of doing that in whatever curriculum and everything. But I am still saying that we maybe are training the wrong people. It's not that you can just pick up anyone and say, oh, come to training, I'll make you a mediator. It's not going to happen. Maybe we've gone wrong there. Countries have gone wrong there. We haven't really got so much of that happening yet. So we're saved right now. So I'm saying that rather than that, if we are going to be able to identify people first and then take them through the route, but how do you identify? Does any training institution say, look, first we will see whether you have the mindset and then only you can enter the training? No. Come to the training, as many as you can, will evaluate you after that. And
I think that's the economic aspect of it.
Yeah.
It's like I was saying before, mediators, you can't survive being just a mediator, right? Except if you're one of those 10. Yeah. You can't survive being a mediator. So what do? You train, and you're training for economic benefit. You may have a feeling of calling as well that you want to, et cetera, et cetera. But the reason that you're training and not mediating is because you can't survive just by mediating. So you do training, I mean, I know in Israel that there's a system for qualifying trainers as well. Not anybody, of course, can train. It has to be, again, all of this stuff is said under the umbrella that all of this stuff is about being on the court list. In other words, training a mediator so that they can be on the court list. It's not training a mediator. Anybody, again, you can train a mediator without having that goal in mind. So there are criteria and procedures for authorizing training institutions from the court side, but that just has to do with the court. That's just for the court ensuring that it has a certain level of quality of trainers and trainees. It doesn't have to do with what you're saying with looking to identify the right people, the people that are that to develop existing talent, perhaps, or not talent necessarily, but to develop this mindset that people have or not.
Because the point is that you have to give the good user experience. Only then will mediation take whatever direction it has to take, only good direction it has to take, will only happen if you are going to give the person a user experience. So is there a problem in terms of user experience that doesn't happen? Otherwise, there's no reason, because I'm on the other side. I'm seeing that there is so much demand. People who've got the user experience are going out and telling people, and there is so much work. Like I keep saying, I can't do all the work there is. There's so much work. Now, how is there such a difference in terms of people looking at mediation the way I look at it and everyone else looks at it? People say there's no work. Why is there a fundamental problem in this way it's structured? So maybe we just have to start looking at that aspect, because finally we'll keep talking within ourselves, but the user has to be there, the user experience has to be there. So I have to bring that out, which is what I'm going to do over some period. That new series of mine will only talk about that, only the positive experiences. So that's going to happen. So I think maybe
that's really important. That's really important to get that out there. Again, I mean, it's a side product. It's a side product of the mandated procedures too. Because if people come out like I did, like I came out, I mean, I came out of it again as a client, not as I didn't go in as a lawyer, and I didn't go in as a mediator into mediation. It's not that I just did a mediation course and then said, okay, now I'm a mediator. I came out of it as a client, and that was the best sales pitch there was to be in a situation where my conflict was mediated. That was the biggest sales pitch,
Because look, again, let me go back to the US market and say that they have not regulated it in so many years, and they haven't found the need to do it, or they're not at the right stage still to do it. So I mean, I think maybe just at the one end we keep saying voluntary process and everything, but as somewhere we want to get into it. Oh, you can do it on your own, this is your dispute, but we will tell you who will be your mediator. You have to choose out of so many people. So the fact is that we have to decide, is it a process where the parties themselves have to trust someone, or is it something that we want to do on a totally different formal kind of a way and bring that down to the grassroots, or take the grassroots, which is what the idea behind the symposium is, the grassroots traditions. Is there something, first of all, is it there? If it's there, are we taking that forward? Because I'm saying maybe India is doing something right. If that 60% of the population rural and only 18 million cases go into court out of 1.3 billion people, maybe we've got something right there. So why not look at that, and rather than you go into the model which has been in a litigious society and we bring that in and spoil maybe the existing system itself. So maybe a lot of questions, a lot of discussion. This is just discussion thing. So, so Giovanni, anything else that you want to bring in?
A lot of stimulus, a lot of questions. For example, just after looking the statistics on mediation in Germany, I had to revise my way of classification of statistics of Italian mediation. The first time that I see the number of the year with CE, I didn't understand the beginning, Christian era, not before after Christ.
Common era. We say common era, not Christian era, because
Well, no, it's extremely interesting because the culture, of course. And you told not you just court and exit mediation, not mediation. People must go to mediation before going to court. And what is really important is just to share, just to widespread the culture of mediation. That's all, I agree. But how? There's the problem. No.
Okay, so we'll discuss that. What I'll do is maybe we can end this session here. If Joao, if you have had any questions or anything, if you have anything, you can bring it in. Otherwise, let's end the session and then we can have the discussion after that. Yep. All right. Perfect. Thanks a lot, Chuck.
Please, the other fellow colleagues, if you have some other
questions. Let's just thank Chuck for his presentation. And definitely, because if the session gets too long and the video gets too long, anyway, people don't watch it. So I think we'll just end it here. All right, thanks, Jack. It was obviously, expected that your presentation is going to be very nice. That was